go ahead and kick off. So good afternoon, everyone, and welcome to Vicente Sederberg's presentation on psychedelic business opportunities in Oregon and Colorado and beyond. Vicente Sederberg is a leading national law firm that focuses primarily on the cannabis and psychedelic space. And we have been leading the advocacy and legal guidance in these fields for over 10 years. My name is Sally Peebles, and I run our firm's Florida practice and keep an eye on what's going on in the Southeast. And I'd like to introduce my colleagues and our panelists today. First, I have Josh Capel. He is one of Vicente Sederberg's founding partners and one of the leaders of our psychedelic practice. He was the co-author of Colorado's Prop 122, as well as the chair of the campaign committee for that referendum. It was just recently passed by Colorado voters to create access to natural psychedelic medicines. We also have Marina Majewska, counsel with Vicente Sederberg and co-chair of the firm's psychedelic practice. During her legal career, she was a research assistant and guide on the psilocybin studies at Johns Hopkins. We're also joined by Jerica Perez. She is a partner of the firm's Colorado's office. She runs our very successful national merit licensing team, helping clients obtain coveted competitive licenses all over the US. And she's also on the board of the National Hispanic Cannabis Council. And last, but certainly not least, our presentation will be kicked off by Yolanda Clark. She's a senior associate in our Colorado office and a lead member of the firm's National Merit Licensing team. Yolanda is currently helping clients in their licensing pursuits under Oregon's new psychedelic program. I also like to provide a brief overview of our presentation today. And we're going to first start off with talking about Oregon's implementation of their psychedelic program. Then we'll shift to Colorado, and then we'll provide an overview of what markets to keep an eye on in the future in the United States. If you do have a question, just please type it into the Q&A feature, and we'll go over those at the end of the presentation. All right, Yolanda, take it away.
Thanks so much, Sally. And looking forward to talking with you all about Oregon's program, which is really, the first of its kind in the nation, and one that we hope to kind of see spread throughout the country as we've seen cannabis in the medical and adult use sectors really expand outward over the past decade. Can we move the slide along there? So just to give you a broad overview on where we are and how we got here. In Oregon, the psilocybin measure was introduced in 2020 and passed in that November election. That was ballot measure 109. And for the past 2 years, they've been kind of in the implementation phase. So because this is a first of its kind program, they really wanted to make sure that they were doing things properly and taking the necessary time to set up everything in a professional and responsible manner. So over this 2-year implementation period, the regulatory agency has been established under the Oregon Health Authority, and they have, importantly, gone through rulemaking. So as of just a couple of weeks ago, in late December of 2022, final rules were adopted, which govern the program, the licensure process, and how this is all going to run to make sure both business organizations and the clients who are undertaking these services remain healthy and have their goals met. There was tons of stakeholder involvement. The regulatory agency had numerous public meetings and hearings where they heard from different stakeholders to inform how this program would be run, and ultimately the final rules that were just adopted. And very exciting news, as of January 2nd, so just a couple of weeks ago, applications are now open. So this program is live and is really ready to kind of get going in earnest now. So just to give some, again, overview on kind of what we're talking about, there are 4 license types for Oregon's program. This is manufacturing, laboratories, service centers, and facilitators. Manufacturing, obviously, is the people cultivating and processing the mushroom and psilocybin products that are going to be ultimately used at these service centers. Service centers are where all of these activities will take place. Unlike cannabis, this is not a situation where you go into a dispensary and walk out the door with psilocybin products. Everything is handled at the service center. Facilitators are individually licensed people who actually help clients through the psilocybin process. So they're going to have a prep session before any psilocybin is administered to kind of go over concerns and just the process on an individual level. There's an administration session where the psilocybin is actually administered. And then there's also what's called an integration session where the clients and facilitators meet afterwards to kind of go over everything and debrief about the experience. Laboratories test the products before they make it to the service centers for use. Some high-level considerations to keep in mind if you are interested in being licensed under this program is that there is a residency requirement. If you're a facilitator, you have to be an Oregon resident for 2 or more years. And if you're any of the other license type, your entity needs to show 50% of your ownership or partnership interests are held by individuals who have been Oregon residents for 2 or more years. This residency requirements does lapse in 2025, but it is something to be aware of if you're looking to get involved early on in the process. Something else to know is that there is a restriction on the financial interest that you can hold in these licenses. So you cannot have more than 1 manufacturing license or more than 5 service center licenses. Now that we have the application, now that it's January, there's some other things that if you're interested in getting involved in this industry that you should kind of keep in mind. So one of the big ones is corporate. Like I said, there is the 50% residency requirement for partnership and ownership interest. So that's really one of the biggest priorities, at least initially. Your entity has to be registered with the Oregon Secretary of State. All individual owners have to be 21 years of age or older. You will be required to go through a background check. And you are required to maintain a list of all entities and individuals who have a financial interest in your business. From a practical standpoint, what this means is when you're going in to apply, this is an online submission, although there is also a mail-in option. You're basically just providing this information and basic corporate structure to the department so they know who is involved in your entity and just making sure that all of their boxes are checked in terms of residency, background checks, all of those kinds of things. So who is actually going to have to provide this information? Individuals for the entities and for facilitators are going to have to provide certain basic contact information. This is going to be basically anyone with 20% or more of an interest in the entity proposed to be licensed or is going to be receiving financial interest, revenue, profit, proceeds from that entity. This is also going to apply to have control over the entity. We've also listed out here just generally from a corporate standpoint, all partners, if you're a limited partnership, all managers and managing members from an LLC, principal officers from corporations, and anyone who meets the requirements from this first bullet point listed on the slides are going to have to provide certain documents and information to the department. Again, this is relatively high level. They are going to ask for your social security number. You're going to have to provide some form of government ID, whether that's a driver's license or passport, to prove your residency and your age. The most impactful portion of the application and the one that's going to be the biggest hurdle for most individuals is going to be the property. So there's various components on things that need to be included in your application, and all of these have to be done before the application. Unlike sometimes where you can apply and then find a property after you've received your license, in this instance, you do need to have a location before you apply. This does not apply to facilitators who, again, are individually licensed. For the rest of the license types, so that's the manufacturers, service centers, and laboratories, you're going to have to provide a land use compatibility statement. This is a form provided by OPS, and which is going to be signed by your local jurisdiction, whether that's a city or county, and which basically confirms that your location and the kind of license that you're, following along for is legally applicable in the jurisdiction. As you may or may not be aware, in this most recent election, there was the opportunity for jurisdictions to opt out of this psilocybin program. We have a handy little map for you there. And there are also resources available on OPS's website to help you identify where certain services are allowed or not. But that is definitely a key consideration. You're also going to, if you don't own the property, can we go back just a second here? Not quite done with that one. If you don't own the property and you're pursuing a manufacturing license, you're going to have property owner consent. As part of your submission, you're also going to have to include a map and plans of the proposed premises, including camera plans and security plans. If you are a service center, there are setback requirements for schools and things like that. So that's another thing that you're going to have to not only confirm, but provide documentation for in your submission. As you go through and as the department is reviewing your submission, you will be required to pass a site inspection before the final license is issued. I also have just a couple of high-level reminders here for everyone. Excuse me. Number one is just make sure that the jurisdiction that you're interested in has not opted out of the program. If they have, you're not going to be able to get your land use compatibility statement, and you don't want to spend money, in an area where you're not going to be able to undertake the activities that you're pursuing. The other thing to keep in mind is, again, just kind of a general reminder, but even if a locality has not opted out and is permitting these services, they still have the ability and the authority to enact time, manner, and place restrictions. So these could be hours of operation, certain zoning restrictions, things like that. So even if the city or county that you're interested in has not opted out, you always need to make sure that you're going through the local ordinances and minutes to make sure that whatever you're trying to do is in the proper zone and that your property is compliant. The final kind of high level thing to keep in mind is the social equity plan. So this is the predominant narrative component and requirement for this application. And as part of that social equity plan, you really need to not only highlight the principles that are going to govern your business, but also provide objective performance measures. So, actionable items and metrics so that they can, they being the OPS, can confirm that you are undertaking the actions that you've said you will in your application and are really striving to meet these social equity goals. And this is especially important because unlike some places where, you might make promises and not always follow through on them, although you should, they are going to be, when you renew your license, they will be asking for documentation showing that you have followed your plan and are meeting your objective performance measures that you outlined in your initial application. If you want to make changes, you can do so, but you have to notify the department. So very important to keep in mind there. The last thing I wanted to touch on today is just some license specific considerations. Most everything that we've spoken about is applicable to all of the license types, but there are a few special things for each of them that what you should be aware of before kind of applying. For manufacturing, again, this is kind of the start of the whole process and the production side of things. When you're applying, you have to choose between 3 possible endorsements. This is fungi cultivation, psilocybin extraction, and edible psilocybin production. You can go for all 3 endorsements, or you can select only one. If you want to change it down the line, you can do so, but you have to select at least one when you're making your initial application submission. Service centers, again, this is where the administration sessions, integration sessions, preparation sessions actually occur, and where psilocybin changes hands from the service center to the client. Again, something very important to keep in mind is all of these activities are supervised by facilitators. So just because you have a service center license, you still need to engage with a licensed facilitator in order to actually offer any of these services. You also need to think about, which goes back to the property, whether you want to offer indoor or outdoor administration sessions, group versus individual administration sessions. And again, these are the sessions where you are actually, the client would be taking and imbibing the psilocybin. So you just have to think about, what makes business sense, what you're offering to your clients, and what makes sense in the locality that you're operating in. For testing labs, you do have to have a separate accreditation from the Oregon Environmental Laboratory Accreditation Program. So do keep that in mind. That is its own separate process outside of the general psilocybin licensure process. And finally, for facilitators, again, this is solely on an individual level. There are no entities that will be licensed as facilitators. You do have to be over 21 years old, and you do have to hold a high school diploma or equivalent. There is no other higher education requirement. There is, though, a separate training course that you have to take. There are several programs available, all of which are listed on OPS's website. And then there is a separate, what they're calling a final exam by OPS that you have to pass before they will issue your license. So a lot of exciting things happening in Oregon. It is relatively straightforward, even though this is a brand new program for psilocybin, and we're hoping to see, kind of expand outward. If you're interested, really hoping to help some clients, and we're already working with several groups in the state to gain these licensures. So happy for anyone who's on the call today to meet their business goals here.
Awesome. Thank you, Yolanda. What a really helpful information. And I think, before I jump into Colorado, I think, looking at Oregon as, sort of the base of where, the Colorado law came from. A lot of the requirements are very similar around preparation sessions and integration sessions, and, in the same sort of structure. So it's, Oregon is the first state to move forward. It's really important to sort of like watch what's going on there. And although we will definitely do things differently in Colorado, Oregon is going to be a good starting point. So Prop 122, what I consider to be one of the best psychedelic laws in the country right now, but I'm obviously biased as as one of the drafters, and I've also been deeply involved in the campaign over the last couple of years. But the measure passed this November with 54% of the vote, well, 53.6, and a lot of folks thought it was really close, but really that was just Denver not counting their votes very quickly. And if Denver counted all their votes on election day, it would have been a clear victory on election night. The when I look at Prop 122, there's really two different components. There's the regulated natural medicine access program that's very similar to Oregon's 109. And also the personal use section. And the personal use section, which Barina will talk about, here in a little bit, is really historic. This component, was not included in 109, and and it is a really key piece of this puzzle to provide, access to natural psychedelic medicines to everyone, and in a manner that that they're the most comfortable with. And so moving on, to the regulated natural medicine program. Big picture, similar to Oregon, it creates a state-regulated model for access to natural psychedelic healing under the supervision of a licensed facilitator. Also similar to Oregon, it only starts with psilocybin and psilocybin. And now, granted, that could be expanded, as we'll talk about. And, so the main part of this regulated program, is the licensed healing centers. And, these, business entities are sort of like a one-size-fits-all license at this point. With a licensed healing center license, you can, you can cultivate mushrooms and psilocybin products. You can extract, you can process, you can sell to other healing centers, and it can also be a spot where the supervised use of natural medicines can occur. Also, similar to Oregon, there's, a limit, there's a limit, so an individual cannot have a financial interest in more than 5 healing centers. And so we don't know how this will, necessarily affect like different public companies that might want to be in this space. But there is, a key difference, is that there is no residency requirement here in Colorado. But there are some other, requirements, around business practices, that we'll dive into. Then, the second, big, component, here's the licensed facilitators, and really these are the linchpins of, the regulated program. And the licensed facilitators, how it's designed in Colorado. Again, there's no prerequisite of a degree, but there is. But there is a provision to allow for relevant experience, whether it's experience with natural medicines or other relevant experience, to be considered in the qualification and credentialing process. And another big difference about how our facilitator, mandate's structured is that it's a tiered system, so there'll be different tiers of facilitator licenses depending on the services being provided. So some facilitators might focus on more of a spiritual, might have more of a spiritual outlook, and others might be strictly therapeutic, and some might just be about health and wellness. And so the idea is to have different tiers of facilitator licenses based off of the services provided and the indications of the participants. If someone's trying to work through trauma, that's different than if someone's trying to looking at their cell phone too much, or or break certain habits. The supervised use piece is key here too. Another big difference from Oregon is that the supervised use can take place outside of healing centers, based off of the regulations that are created. And so in Prop 122, we sort of mandate, hey, we got to make regulations of what does home use look like, and and having facilitators come to someone's house or come to another healthcare facility. And this is key for nursing homes or end-of-life patients, and also for addiction treatment centers. And so there's a mandate to create rules around where natural medicine services can take place. A big piece of this too is that there's no sales. This is not the next cannabis industry. This is not like, there's not going to be the commodification of retail sales products. Everything on the regulated side is about being used under supervision of a licensed facilitator. And right now as well, the regulatory agency is DORA, the Department of Revenue, or not the Department of Regulatory Affairs, which also regulates other professions, therapists, nurses, et cetera. And it's really exciting, that we'll have a new profession in Colorado, this licensed facilitator, licensed psychedelic facilitator. And so, a lot of folks right now are talking about the advisory board. There's, we're deep into the advisory board process. Ultimately it's the governor's decision, of who they're going to appoint. We should expect some appointments made in the next 18 days. There's a lot of interviews that have been going on. The applications close at the end of the month. One good thing, is that, or at least I'm hoping for, is that there'll be, potential working groups and subcommittees under the advisory board. So, hopefully we can really, for those who apply to the advisory board who may not get on it or who want to get involved, hopefully there can be, working groups and subcommittees around around a lot of these key topics around equitable access and Indigenous reciprocity or benefit honoring, or what sort of guardrails and safety do we need? What do these training requirements look like? And so, lots, still to be developed. Here's a timeline. As I mentioned, the advisory board, needs to be appointed by the end of the month. By, I guess, almost this time next year, there should be rules for facilitator trainings and approved training programs. So it's a super tight timeline there. Then, by September 1st, 2024, that's when all of the rules should be finalized, with applications opening at that time. And then, June 2026, that's when the advisory board, can recommend whether other natural medicines are listed in Prop 122 should be added to the regulated program. And to be honest, no one really knows. I think there's a lot of each natural medicine is very different, and there's a lot of different sustainability and environmental and cultural considerations around each of these natural medicines, and they need to be very thoughtfully unpacked before they're just sort of thrown into a regulatory system by the state. Things to watch. So first, I think it's worth pointing out to everyone that this is a state-based program that's illegal under federal law, and and so we don't know exactly how the federal government's going to react. We haven't seen any movement in Oregon, but things are still getting started, and so watching what happens at the federal level is very key. And and along those lines, there's also different considerations, as it relates to DEA licensure, when you're, the intersection of a federal program and a state-based program, because of the state's illegality at this time. With that said, there has been rumors, and many people have seen on the news of, a federal task force being created under Health and Human Services with SAMHSA to try and provide some guidance, to try and tackle what does federal psychedelic policy look like, both at a federal level of what are we doing with different pharmaceutical companies, at a state level, what are they going to do with Oregon and Colorado? Are we going to see some memo of non-enforcement like we saw in cannabis, like the Cole memorandum, or what's that going to look like? And then also, like, the federal task force might, take up, RFRA and sort of like, the religious use of these substances under federal law as well. So a very key thing to watch out for, over the next couple months. Another big piece, to watch out in Colorado is the state legislature. This is it's a statutory measure. The state legislature has the power to change it. And, and so, I believe that, I do trust, most of our state representatives that they'll follow the will of the people, but I wouldn't be surprised if there's some tinkering, with, just some of the mechanics in the bill or maybe the timelines. With that said, also wouldn't be surprised if there's some state legislatures that don't believe in the will of the people and, and want to try and gut this measure, and just ignore democracy. But at the end of the day, I think overall, I do think the state legislature will follow the will of the people and, honor the intent of Prop 122 here. The third thing to watch out for, and, I guess the trifecta of governments is the local governments. Every local government, in the next couple of years has to, create time, place, and manner regulations and zoning regulations. So for those who, are hoping to turn, their ketamine clinic, and add psilocybin, ultimately that's going to come down to how your local government is going to zone healing centers. And, and it's a little unclear, of what that will look like. I do think, for, communities that, have voted overwhelmingly, I think we'll see a lot more, support and a lot easier, zoning regulations, and for communities that maybe didn't pass it or just have, frustrating local officials, it might be a little bit more difficult. And so for those who are looking at like, hey, where can I have one of these healing centers? It's going to be a big local government, game. And it's also something to think about, like, what is the use you're trying to use a healing center for, which I'll talk about in a second. And then the state regulations. I think there's, how the measures design, and we touched on some of this already, but how the measures design is really sort of like the frame of the house. And what this look like, what it looks like will be, determined through the state regulations. And so, there's a mandate, in Prop 122 to create a program that, that has equitable access to psychedelic assisted therapy, or actually equitable access to these natural medicines, and also equitable ownership of these healing centers. And so what that program looks like is ultimately going to be up to the regulations. And it could be something that's really meaningful and really effective, or it could be something that's not, and so, so we really have to watch, what happens here, and same, with the ESG screen, in the measure, there's a first of its kind, business practices screen around environmental, social, and governance standards, and other factors, that the state's got to create a screen that sort of goes through every business's, current or proposed business practices and ranks them and gives them a score. And then, if that score reaches a certain level, then they actually qualify to do business. And so, one of my hopes is that we can build in some sort of benefit honoring or reciprocity into this ESG screen, and really sort of mandate or encourage giving back to, communities that held these medicines sacred. And so, but whether or not that screen's effective or not is ultimately going to come down to this regulatory process. Another thing is the locations, as I mentioned earlier. It's like, what sort of rules are going to be around, natural medicine services at healthcare facilities or at someone's home? Is it going to be limited to people who are disabled or can't leave the house, or will you be able to, have a psychedelic party and have a facilitator come over? Like, who knows what this looks like? And all that's going to be decided, in the state regulations. Same with facilitator training. What sort of requirements are how many hours is it going to take? Is it going to be 40 hours? Is it going to be 250 hours? Is it going to be 1,000 hours? How are we going to create a stackable system that's equitable with sort of on ramps and off ramps in the credentialing process? Again, key thing to watch out for. Guardrails, what sort of, screening processes, disclosure statements, will there be prohibitions on folks maybe who use lithium from engaging in psilocybin? Like, what does that look like? Another thing to watch out for. Testing labs is one of my favorites. The, in Prop 122, there's, mandate for testing labs to be created. And the mandate includes, I guess it's not made, but it provides the ability for these testing labs to test products on the personal use side. And so whether or not these labs can engage in testing personal use products, I think is also something that comes out, through this regulatory process. And I sure hope that it does. And then products, this is a big one. As we saw in Oregon, there's a limitation on, different strains of psilocybin, that you can grow. And will we have more variety here in Colorado? Will we be able to add niacin or lion's mane or other herbal supplements to these products? What sort of packaging requirements will be will be implemented? Again, like all this will come out in this like state regulatory process over the next 2 years. And so what can you do now? I mean, I think a big piece of this, when people call our office and they say, hey, we're interested in opening up a business, the first thing is like, it's like, well, what is your relationship with these natural medicines? Do you have a relationship with these medicines and with these services that you want to create a business around? And so I think that's a big part of it is like, a big first step is going inward and exploring your relationship. And with that said, it's like you can go, hopefully there'll be, psilocybin service centers opening in Oregon, but there's other places, I guess around, really sort of like around North America or around the world where you can, have, regulated or, I guess like above ground experiences, but there's also below ground experiences you can have in natural medicines. And there's also our whole personal use section that, Barina will talk about here in a little bit. Also learn, it's like there's, the facilitator training programs are open right now in Oregon, like take a facilitator training course, learn about this business and also study the traditions, it's like what traditions have kept these medicines sacred and study those and really, get in deep, with where these medicines have come from and what's their history, and also study the research about them. There's so much research going on around these natural medicines for addiction, for PTSD, for anxiety. It's like really understand, what is the latest research. And then like determine like what sort of business model, you want. Are you, if you're going to open a healing center, is it going to be, are you looking more on a therapeutic side or more of like a retreat center model or something completely different? Do you want to cultivate mushrooms? Do you want to process mushrooms? Like, what does that look like? And I don't have it here, but like, or do you just want to be a facilitator? Or do you want to create a co-op of facilitators or a facilitator training business? Start to flesh out what that looks like. And then as I mentioned, with the state ESG screen, start to think about, hey, what would it look like for my business to go through an ESG screen? Am I paying my employees, fair, above a living wage? Am I giving them, really good benefits? Because all those sort of items would be, will be scored on this ESG screen, and they also affect your financial modeling. So build that in at the beginning. And then I can't stress it enough. It's like, for businesses, that are building a business off of sacred medicines that have been held, by intergenerational wisdom traditions for so long. It's like, what sort of benefit honoring? Like, what are you going to give back to these, communities, and what does that look like? I think it's a key piece of this plan, and and as I mentioned, it's like it's hopefully something we can see in this ESG screen. Because to me, it's very key that we're honoring the groups and the indigenous groups who have been using these medicines and keeping them sacred. All right, more things you can do. You can also create the entity. We can help you set up the business entity. 280E, as it relates to taxes, is still an issue. And so you want to think about tax strategies, and for those who don't know 280E, who didn't come from, the cannabis space, what it means is to the extent you're trafficking a controlled substance, you can't take necessary and ordinary business deductions. And so there's a lot of unanswered questions as it relates to what is trafficking, what does this look, is it the administration of psilocybin or is it the whole facility? And so there's a lot of unanswered questions around there, but key things to think about when you're forming the entity. Build the team. Who's going to be part of your team? Who's, what facilitators are you working with? Raise risk capital. As mentioned, this is still illegal under federal law. Like it'll require capital to, obtain a lease and or buy a property or really sort of even develop your business plan. And so it's, and a lot of it's risky, so that's like something you can do now. As I mentioned about earlier with local governments, like determining potential locations, you can sort of look at what, like what community is overwhelmingly supported this and sort of like start there. It's like, okay, they'll probably have hopefully relatively friendly, local government laws, but but it's still a gamble, until the local governments have, actually, passed time, place, and manner regulations. There's just not much, that can be done, in terms of like actually acquiring a property. With that said, though, for those who do want to gamble, I think one way to look at it is, hey, what is the use of your business absent psilocybin? Are you a therapy office? Are you a manufacturing facility? Are you a retreat center? Are you looking at locations that are zoned for those types of uses, absent, this, natural medicine overlay? And then finally, get involved. There's get involved, in your local government. There's going to be, a lot of, probably public hearings and ordinances around this. Try and find those, those county commissioner or city council, representatives are going to be champions on this issue, and support them, and whether it's like providing them education or showing up at their meetings, and just get your voice heard. And same at the state level, as we sort of went through, there's a whole host of different regulations that are coming down. All of those regulations, will be enacted through a public rulemaking process. And so there'll be the ability to comment, and there'll be the ability to testify and get involved in sort of like the regulatory process. And for some, who don't have, the time to sort of get involved, there is, the ability to hire like professional lobbyists or professional representation, around this. And VS Strategies, which is a sister company, has helped a lot of, different companies, advocate for themselves in a professional manner. And with that, I'll turn things over to Barina.
Thanks, Josh. And hey, everyone. Thanks for joining us here today. And Josh, thank you both for running us through the regulated access provisions and also for all your efforts on Prop 122. I know I appreciate it, and I hear a lot from folks who do as well. So Josh just spoke to you guys about the regulated access provisions. That was sort of the last chunk of the detail he gave you. And I'm going to follow that up by giving you more detail around the personal use provisions. And as we go through this, just to help you guys think about it, I think it's really important to keep in mind that this is a separate prong of the Natural Medicine Health Act. It covers different territory than the regulated access provisions. So as I'm talking through this, let's be careful not to conflate the rules of the two different prongs, because there are some nuances in the personal use provisions that are very different than the nuances of regulated access. So we want to keep these conceptually separate. And most people who are interested in taking advantage of either of these prongs will be operating under either one of these prongs or the other. Most likely it won't very often be both. So an important first question and distinction is what natural medicines are included under the personal use provisions. So unlike under the regulated access provisions, which as Josh mentioned, only include psilocybin and psilocin until the board recommends expanding the medicines that are included, which can't happen until I think 2026. For the personal use provisions, the definition of natural medicines is broader, and it includes DMT, ibogaine, mescaline, but specifically excluding peyote for environmental and cultural reasons, and then also psilocybin and psilocin. So that's the bucket of medicines that we're talking about as we go through these personal use provisions. So it's also helpful to understand why we have the personal use provisions, right? It's different than Oregon, where we have a regulated model and then the decrim that got passed in Oregon. This is a little bit different, right? So these personal use provisions are not intended to be redundant with the regulated access prong. The regulated access prong already establishes sort of a commercial or regulated system for the use of certain medicines in certain contexts. And we're not trying to expand that or repeat that, like create another parallel regulated system through the personal use prong, right? So the personal use prong's intentions are different. And some of the considerations that led to establishing the personal use provisions were that the drafters wanted to provide individuals options regarding their mental health. For example, treating their depression, their own depression, anxiety, and addiction. Drafters also wanted to provide individuals options for their spiritual growth, right? And as most of you probably know, there's good research about the different forms of spiritual development and mental health treatment that can occur through these. But there's an intention to provide a different set of options than what's going to be available to folks under the regulated access model. And then the drafters also wanted to remove penalties for indigenous and traditional uses of these medicines, which, as you guys know, are very expensive, right? So it's helpful to keep these intentions in mind as we cover the nuances of the personal use prong, because I think it'll help explain why some of them are created the way that they are. Okay, so let's do a general overview of the personal use prong, and then we'll get into some more of the weeds and the nitty-gritty of it. If you're an adult that's 21 years old or older, the personal use provisions allow you to obtain, grow, process, store, transport, and use natural medicines for your own personal use, right? So that's the first part that's relatively easy to understand. The second prong is it also lets you give away natural medicine to other adults, right? Just give it away, does not allow sales, which we'll talk about several times here, but you are allowed to give it away to other adults with important restrictions that we'll discuss in a minute. And it also allows you to share natural medicine with other adults in connection with certain uses, spiritual and community uses, bona fide harm reduction, support services, and bona fide therapy. So these are the kind of general categories that the personal use provisions are intended to address. And of course, one of the first questions that comes up here is, what is a personal use amount? The personal use prong protects personal use amounts only, right? So what is a personal use amount? The actual amount is not defined in the act, so you can't go and read it and say, okay, it's X number of grams of this, but Y number of grams of this other medicine. But personal use is defined as the personal ingestion of natural medicines. But then the language goes on and expands it a little bit further and says it also includes the amounts necessary to share in these certain approved contexts: counseling, spiritual guidance, beneficial community-based use, healing and supported use, and related services. And we'll kind of come back over and over to these same buckets of uses that the personal use provisions contemplate. So we'll see how this ends up playing out, right? But what we do know at the outset is it needs to be a reasonable amount, given the way that the Act defines personal use, right? So at the very least, we know it means you can't be cultivating hundreds of pounds of mushrooms every week and thinking that you're operating under the personal use provisions. You won't be. And more detail on that, I think we'll see as this gets implemented and rolled out. So let's talk about restrictions relevant to therapists, ceremonial leaders, and other facilitators, right? This is sort of where it's very practical advice if you're thinking of operating in any way or taking advantage of the personal use provisions. These are some of the main things you need to keep in mind. Again, remember, this is additional to and separate from working within the regulated access prong, right? So you're going to be subject to different limitations here. The intent is to allow people providing these types of approved bona fide services to be able to give away natural medicine in connection with their services, but not to sell the medicine, right? So you can't be providing some of these approved services. For example, you can't be a licensed therapist providing bona fide therapy, but also be selling natural medicines under the personal use prong. That's not permitted. So this is not intended to cover or protect any sales. And then obviously we can look at a business model and start to get a sense of whether it's actually a sale or a sharing of natural medicine in connection with these approved services. So in a way that might play out is if you're a licensed therapist and you're charging $150 an hour for a normal therapy session, but you charge $500 an hour for psilocybin therapy, where you're also providing the mushrooms, it starts to look a lot like you're selling the mushrooms, right? And that's not permitted, and that's not what the personal use provisions are intended to protect. You also can't give away natural medicines as part of a business promotion or other commercial activity. So say you wrote a really wonderful book on spiritual enlightenment. You can't give your book away and then give little bags of DMT away with it, right? That's not protected under the personal use provisions. that would qualify as part of a business promotion or commercial activity, and that's specifically not what's intended to be protected here. And then furthermore, even in connection with your bona fide services, like the ones we're discussing here, you can't have paid advertising in connection with services related to natural medicine. And in fact, the Act explicitly says that engaging in paid advertising may be considered evidence of the commercial activity that's specifically prohibited under the personal use prong. So if you're running ayahuasca circles and you have paid advertising, Facebook ads or things like that about your ayahuasca circles, you're probably engaging in commercial activity under the personal use prong, and it's very likely not protected. Interestingly, it does say that the language here around commercial activity is not intended to preclude payment for bona fide harm reduction services or the other bona fide services that it lists. So simply getting paid for your time and not for the medicines is likely not commercial activity, as long as you're complying with the other subtleties of this, like not engaging in paid advertising. So this section basically needs to be understood really carefully, and people that want to operate under the personal use provisions need to really carefully go through the Act and make sure, with help from VS, with help from another law firm, whatever it is, really like make sure that you understand these and you're operating within these limitations, because they are nuanced. And so you need to have some precision to be complying with them. And we can expect, I think, some bad actors to inappropriately try to use the personal use prong for commercial activity, try to get away with commercial activity under the personal use prong. And I think we can definitely expect that to be shut down. And worse than being shut down, it could also create a legislative backlash that ends up limiting the applicability of the personal use provisions, to be narrower than what folks voted for. So, there's a lot of incentive to understand these provisions, operate within them, and not try to take advantage of them. Just try to operate within them in the way that they're intended. All right, so we've talked a bit about the limitations of the personal use provisions, what you have to do to play within its confines. Once you do play within the terms of the personal use provisions, they have specifically built-in protections for people. So the drafters wanted to reduce certain risks that people using or sharing natural medicines might otherwise be subject to. So when you operate within the confines of personal use, you get the benefit of certain protections. And again, these protections will only apply if your conduct complies with the personal use provisions. So first, it protects against professional discipline and a loss of your professional license for providing services in connection with natural medicines. Again, within the context of the kind of services that we've discussed: harm reduction, community and spiritual services, bona fide therapy services. So this protection will apply to people like licensed therapists or doctors, right? So just because you're providing medicine in connection with your licensed services, that won't automatically subject you to discipline under your licensing board, right? But importantly, this doesn't permit malpractice. So if you are a licensed therapist, for example, and you're giving away natural medicines, but you're doing it, largely within the confines of the personal use provisions, but you do something that's irresponsible there, right? Whether that's around dosage or the way you're sitting with people in a way that constitutes malpractice, you lose the protections of the personal use provisions there, right? So once you're in the malpractice range, you can't point to the personal use provisions and rely on this protection to protect you from disciplinary action or even loss of your license. And then the personal use prong has a wide range of other protections as well. In the interest of time, I think I'll go through them kind of quickly, but they're really quite thoughtful, I think, in the way that they were drafted. So an adult engaging in conduct permitted by the personal use prong by itself can't be considered child abuse without a showing of additional acts by that adult that threaten the health or welfare of a child. And similarly, such conduct, the kind of conduct that the personal use section allows, that can't be a reason to deny a parent time with his or her child unless there's additional separate risk to the child. You can't use conduct permitted by the personal use prong by itself, again, to deny eligibility for state public assistance or to disqualify someone from medical care, medical insurance, or qualification for organ transplants. And I think very importantly, it provides certain criminal law protections. People that have already completed a sentence for criminal conviction before this act was in effect, where their conduct would be protected by this act, can now petition to have their records sealed. Again, conduct protected under the personal use prong cannot be the basis for detention, search, or arrest, and natural medicines cannot be seized as contraband. Again, if your use of them or your possession of them is compliant with the personal use prong. So there are all these different layers of protection that I think are very thoughtful ways to guard people who are complying with the personal use section from sort of outside liability. And then having said that, there are certain acts that the personal use provisions clearly do not protect, right? And it's very important to understand these in this discussion. It does not protect any sales of natural medicine. So if you're selling natural medicine, even if you've sort of constructed your business model to not look like that, as soon as you're selling, you're not within the personal use prong anymore. And because the personal use prong protections don't apply, any sale is going to be a distribution of a controlled substance, which is a state felony. No giving natural medicines to those under 21. Again, giving controlled substances to children is a state felony in Colorado. So to participate in the personal use provisions, you have to be an adult and the people you're sharing medicine with have to be adults. Personal use provisions also protect cultivation only in private homes or residences. So there's no cultivation allowed in commercial spaces or public spaces. And also wherever you are cultivating in your private home, you have to prevent access to the plants or the fungi by children under 21. And then also it's important to remember, as Josh mentioned, the personal use prong is basically just applying to override state criminal law, right? It's not capable of overriding federal law. And state law does not apply on federal land. So the personal use prong won't protect you if you're on federal land. So federal lands include national parks, wilderness areas, public domain land. So a way that this might play out is if you're a facilitator, you can't take your client to a national park and have them dosed with natural medicine there, right? You won't be protected under the personal use prong. No possession or use in schools, detention facilities, or public places unless it was a public space that was specifically designated for natural medicine use under the regulated access provisions. The personal use provisions do not protect any conduct that endangers or harms other people, and that includes, but is not limited to DUIs. So you can't use natural medicines while operating any car, boat, aircraft. As soon as you do, you're outside the protections of the personal use prong. And then any conduct that constitutes child endangerment is not protected. So as we mentioned on the last slide, the personal use prong does protect natural medicine use as long as you're within the personal use prong, within those confines. It protects that conduct from being considered child abuse by itself, right? But if you're actually endangering a child's health or welfare, then you're outside the personal use prong, and so you don't get the advantage of those protections. So to oversimplify this, a way to think about it is actions that are harmful to a child are not okay just because natural medicine was involved, obviously, right? And then, but on the other hand, just because natural medicine is involved doesn't mean that we assume it's harmful to a child. There needs to be an assessment of the other facts. And I know we're running a bit low on time here, but I think that's all I have to say. I know that there was a lot of information there, and familiarizing yourself with the contours of the personal use provisions will help you guys operate responsibly and legally in the new field. And that's definitely what we want from a health perspective, right? We want this to be a healthy, thriving community. And also importantly, if the community can't regulate itself, I think we are likely to see the state step in with stricter rules around personal use. So my personal agenda here, and I know that a lot of folks at BS feel this way, is we want to create as many good examples of people working with natural medicines as possible, right? So we feel very strongly about helping you guys do that, and please come to us with questions. And with that, I will pass it on to Jericho.
Hi, everyone. Great to be here today. I'm here to talk to you all about what's on the horizon. So obviously, we just went into great detail about the programs in Oregon and here in Colorado. If you're interested in this subject, you are probably well aware that right now there are well over a dozen states in the US considering psychedelic reform for the 2023 session. Very exciting. We're seeing this in all different stages, right? So this doesn't mean that every one of these states is considering a program similar to Oregon's or Colorado's, where we're going to see centers and facilitators. We're seeing everything from legislation that would allow the setup of a task force to research and study what accessibility may look like for that particular state, all the way to legalizing simple possession of certain psychedelics, to regulating and licensing fully therapeutic access programs, like we're seeing in Oregon and Colorado. So all different levels. I do want to talk a little bit about some particular states we're seeing. This is obviously just a very small sampling, what you're seeing on the screen here. Some of this legislation in particular states is specific to psilocybin. Some of it is covering a number of natural medicines like DMT, ibogaine, mescaline, and psilocybin, among others. And then we're also seeing a lot of states build in automatic expungement for psilocybin or other psychedelic-related offenses, which is wonderful. In New York, for example, we are seeing a wide range of psychedelic reform in that proposed legislation, which is exciting. That would include DMT, ibogaine, mescaline, psilocybin, and psilocin. California recently filed a bill that would legalize possession, preparation, obtaining, and transfer of these types of products. Illinois just recently, this past week, filed the Compassionate Use and Research of Entheogens Act. This is specific to psilocybin right now. It would remove it from the state's controlled substance list. It would facilitate expungements, which is something we like to see in all of these laws. We're also seeing legislation in Missouri, New Jersey, and Virginia. Right now, there is some rumor mill that we will soon see draft legislation in Arizona, Florida, and Nevada. And task forces are actually currently operating or working on getting up and running in states like Washington, Minnesota, and Hawaii. So a lot of exciting things happen. There's a lot of exciting things happening abroad as well. We did keep this to the US, but we are well aware of those other things happening, not in the US, and we're happy to discuss those too outside of this particular presentation. Next slide, please. So how can VS help? I think Josh touched on this a little bit in regards to Colorado, but similar to what we've done in cannabis, and with Josh having led Prop 122, I think there's a lot we can do now, even though in Colorado, we are going to see a long runway before the program is actually implemented and open. Oregon, it's obviously open right now. Sally Peebles, who introed us, is at Barden, Oregon. So we are ready and willing to help there. We've already started that. Generally, I think we can obviously help with understanding these laws, their implementation, and evolution. So as you heard from Barina and Yolanda, these laws are very, very nuanced. There's so many aspects to consider in these programs and to make sure you're operating compliantly, because like Barina said, we want to make sure that we're assisting model operators, that we are the example for what these programs should look like, right? And that will hopefully provide extensive access across the US. Once, just like with Colorado and cannabis, while this is a completely different program, other states will learn from our example, as well as Oregon's. Business planning, financial modeling, and market projections. So you may be familiar with Andrew Livingston, our firm, our director of economics. Andrew does a fantastic job of financial modeling and market projections. He'll be doing this and has done this for psychedelic reform in regards to looking at patient data, comparing that against the law for what sort of treatment's going to be allowed, for what sort of symptoms. He's beginning that work, and we're super happy to help you guys with that. License applications, like Yolanda and Barina talked about, Oregon is open right now. Manufacturing, laboratory service center license and service center licensing, as well as facilitators, and understanding what's required for those license application, what needs to be done, and then of course the next steps to becoming operational. That would go for Colorado as well, with healing centers and facilitators. While there is a long runway, there's a lot of business planning that can be done now so that you're ready as soon as those applications do become available. Formation and corporate work and intercompany agreements. As always, this is sort of a step one, right? Getting your company set up, your owners and investors, if you have them, comfortable, fundraising. So again, when your business is ready to open, we're ready to submit those applications and get you started. And then, of course, client forms and waivers of liability. We have bar coverage in multiple different states, and that includes Oregon and obviously Colorado. And we're ready to help you guys with whatever you may need. I also want to talk to you a little bit about our sister affiliate, our consulting affiliate, VS Strategies, who you may be familiar with. As far as Prop 122 implementation goes, they're a fantastic resource for policy monitoring, tracking, and analysis, government relations and advocacy, whether it be at the state or the local level, incredibly effective in making sure, that the right policy is being put into place, whether it be on the state or local level. Representation in legislative and rulemaking processes, and here in Colorado, over the next 2 years, that is going to be a big part of this with the working groups and the advisory board. Drafting legislative regulatory language and comments, strategic communications and thought leadership, and local policy and government affairs. They're just a fantastic liaison. They're familiar with most of all of the state representatives, all of the regulatory representatives who will be designing and implementing all of this policy, as well as the local leaders that are going to be making decisions on this too. So a fantastic resource. You can reach them at vsstrategies.com. And then I think on our last slide, we have contact information for all of us as well. I know we have a number of questions, and I believe we are over. Are there any questions, guys, that anyone wants to take? I do apologize, everyone, that we went a little over, but please email us your questions. All of our emails are there. We're more than happy to get on the phone, email you, and answer as many questions as we can. Please do use us as a resource. We appreciate everyone attending. Thanks so much.